Can a judge prohibit cameras in the courthouse? All right, my name is Anthony Bandiero, bringing the roadside chat. This question comes from an officer in Alabama. So they said they have a judge who posted a order that there be no cameras in the hallway, right? So I guess they're having auditors come into the courthouse with cameras. They are just standing around, and filming, which draws attention to their eccentric behavior, but they're uploading to YouTube. So there's kind of like this purpose there to get some likes, subscribes, and so forth, right? Recently, a court judge, a circuit court judge, posted an order that reads no cameras in the magistrate's office Judge so and so. Okay. So this is a public office. I have sent a question to our attorney, but the DA has no answer. It can be complicated. I understand that. I know a judge can issue orders for their courtrooms, but the officer is concerned, is this okay, right? Is this too much, right? So, and the officer cites to code 13A-10-2 for obstructing a governmental operation. The officer said he's aware of a similar scenario in Oklahoma and Georgia. I guess Oklahoma, they did not throw them out, and in Georgia, the camera was, I guess, prohibited, right, for courtroom security purposes. So, and the officer's asking, what do I think? Well, first of all, let me just make sure that, obviously, this is above our pay grade, right? This is just for conversation. Especially this case, these cases are very fact intensive, very complicated. The First Amendment is obviously very highly litigated. I like to say that the First Amendment is also the most protected, right? I would like to think that the Fourth Amendment, I would love to think that the Second Amendment is very protected, and I would love it to be the most protected personally, because I think that without the Second Amendment, it's hard to have the First and the Fourth, but I digress. But the point is, the First Amendment is highly litigated and very fact-specific cases, because we do know that the Supreme Court allows a certain amount of restrictions on the First Amendment if it's a time, place, manner restriction. In other words, you can't yell fire in a crowded theater, and there may be restrictions on religious speech in a neighborhood, yelling this speech in a neighborhood at 3 o'clock in the morning. But if they're doing the same thing in a public forum at 3 o'clock in the afternoon, maybe they can't restrict that, right? So, okay, and I do want to talk about a case called United States versus Cohen, which is a case from 1971 where Cohen went into a California courthouse, not necessarily, well, maybe a courtroom too, but he went into a courthouse and he had a jacket that said, fuck the draft, right? I'm going to tell you exactly, not F the draft. It actually said, fuck the draft. And, kids were in there, and parents and people getting married, and people going through their court, proceedings, and, people with selective service obligations were in there. And a cop arrested Cohen and said, look, this is vulgar. It's disrupting courtroom procedure. People don't like it. It's immoral that you have this vulgarity on your jacket, and and so forth. And it goes all the way up to the Supreme Court, and essentially the Supreme Court said that was not allowed because one man's lyric is another man's one man's vulgarity is another man's lyric, right? And I mean, you think about rap music today; some of it can be extremely vulgar, and but it has a message, right? And a lot of it's there's a lot of political message in there. And so, but the court, of course, left open this idea that there can be some restrictions in a courthouse. It's not, the whole courthouse is not a public square, right? But it is still a public building, and, you got to be careful with the First Amendment. So I just kind of wrote down some things to consider. Number one, we do know that judges generally have judicial authority to control the manner of how the courts operate. Yes, they can make you take off your hat. Yes, they can have you stand up if you're able to stand up, and when the judge enters the room, and he can hold you in contempt if you break these rules. The rules are to reinforce the the formality and solemnity of the courthouse and the procedure and the proceedings. We also know that the First Amendment does not stop at the the stairs of the courthouse. That there's definitely a right to free speech. I can certainly imagine that you have a defendant who is asked, do you want to say something on the record, and starts going into this diatribe of, injustice and this and that, and, saying things that are offensive to the judge, maybe insulting the judge in one way or another about the judge's character. And the judge should be very careful about saying, well, you can't say that, right? As long as it's related to the proceedings, maybe they're totally off topic and talking about UFOs and Martians. Maybe they just, you can say it, but we just can't say it right now because we're talking about your sexual assault trial. But if they want to talk about how, the justice system is rigged, I would be very careful in shutting that person down. We also do know that cameras can be restricted in a courthouse. In fact, there is a Supreme Court case called Chandler versus Florida, a case from the Supreme Court from 1981 that did say that courts are allowed to restrict camera use if they would be disruptive and so forth. Many courts do allow the media to apply for a waiver, but there's one court that never allows cameras in their courthouse. You know who that court is? The U.S. Supreme Court. So they're not allowing it. But I do want to make a distinction, right? So this is not the chambers, right? Or the actual courtroom. We're talking, this order presumably restricts cameras from anywhere in the courthouse. And, that to me sends some red flags, right? If it's strictly, you just cannot be a First Amendment auditor in a courthouse. You can't even memorialize what you see with your cell phone. I would be cautious on that and think that, maybe that is maybe a little overbroad, right? Again, it's above our pay grade and so forth, but I would be cautious of that. So, but we know that in the actual courtroom, they can be restricted. And so, and we'll talk about obstruction of governmental operations. So, according to my research, Alabama Code, the 13A-10-2 defines obstructing governmental operations as intentionally obstructing, impairing, or hindering the administration of law or other governmental function by any public servant. To charge someone under this code, you would need to establish that their conduct actually hindered or impaired governmental function. Simply filming without more might not rise to the level of obstruction unless the conduct was actually disruptive. And also, I would look for an intent requirement there. Now, we also know from several cases around the country, including Glick, a case out of the First Circuit, that filming, the actual idea of filming, is also protected, by the First Amendment. It is a First Amendment right. And the way the courts look at it is the right to speak also applies to the right to gather information, right? How can you speak about something? How can you be knowledgeable? How can you share your concerns if you can't even record what you are talking about, right? So let me give you an example. There was a case out of Illinois, I believe. The state doesn't matter, but I think it was Illinois, where a local jurisdiction, enacted a law that you could not film children in a park. I get it. We're trying to, control the creepers, right? Well, this person filmed the park with all these kids in there, and then went to the city council to show the city council that the parks are being overused. And I think the message was, we need more parks. Well, they straight up charged her with violating the whole, you film my kids, you can't film kids. And I'm sorry, but look, with those facts and those facts alone, that is absolutely asinine that any officer would even be on the receiving end of that order by some mayor or something, like, hey, charge this person now. I know they're coming here and they're complaining about the parks. Now charge them with violating this law. I would hope that some cop, the cops out there be like, no, give me a judge's order first, because they're just showing you what they observed. They're complaining about something. It's not the creeper that's not the creeper. It's not the intent of the law. So they said that the law was facially invalid, because how can you enforce that, right? You can't just film kids. What if you want to film your kid's soccer practice, but other kids are in the film. So anyway, the point is, we leave here with a few principles. First of all, I do not know if this is lawful. I cannot tell you that, right? Number one, there's no way that my little 10-minute discussion on this is in depth enough to really understand what exactly is going on in that particular courthouse. But we will leave off with a few pro tips. Number one, the First Amendment does not stop at the courthouse steps. It applies inside. Number two, judges have very vast authority to control the judicial process inside the courthouse, especially in the courtroom and in chambers. Number three, the Supreme Court has said that limiting camera use can be constitutional in the right context. And number four, if you are going to enforce a law against somebody for filming, being a First Amendment auditor, and, I would ask, are they lawfully present? Are they allowed to be there? Are they actually trespassing? But if they are lawfully there and they are engaged in some First Amendment activity, meaning they're trying to gather information to show the world about something that's going on, I personally would be very careful on hitting that person with obstructing governmental procedures without a little more support by my command. Because, again, if my boss is telling me to do it, it's not clear either way. So it's not like a clear violation of the Constitution at this point. I would love for my boss to be like, yep, we're on board here. Go ahead and charge him. That way that we can push up the chain if we do get in trouble. If we get sued, like, hey, my sergeant told me to do it, right? I expressed my concern. My sergeant, lieutenant, my chief said it was okay. Or even better would be somebody from the DA's office saying, yep, we will prosecute that case. That will give you some confidence that the way that they're looking at it is lawful. Okay? Good conversation. Something kind of a little off the beaten track from what we normally do around here, but I hope you like what we're doing here. If you do, like, subscribe, share with your friends, right? And until next time, my friends, you stay safe.